Okay, thank you very much. Well, that was in fact a very good segue into my discussion, because it turns out that I think the discussion that was just made by our friends in Cyprus, in fact, tracks my work almost completely. So they saved quite a bit of time. One of the things I was struck by when I attended the kickoff meeting in Maribor and also Cyprus, and then looking at the questionnaire that we prepared for this project, was terminology. What's the difference between a decree and a judgment, for example? What's contained in a judgment? How do parties in a subsequent litigation look back at an earlier litigation and determine whether or not a question has already been decided and may be subject to doctrines of either claim preclusion or issue preclusion? And it's there in particular that I think the United States has quite a different position than here in Europe. So I'll try to hit on maybe some things which are a little bit new. So the doctrine of res judicata concerns itself with the preclusive effects of a judgment, and to have preclusive effects, at a minimum, there must be a judgment, and that judgment must be final. Okay, this sounds pretty simple, and yet there's a treatise in the United States by Wright, Miller, and Cooper that, in talking about res judicata, a very simple phrase in judgments, goes on for 1,000 pages. So the details are, in fact, the devil's in the details. So we have to ask, what's a judgment? What is the form of a judgment? And when does a judgment become final? And we really can't understand the current law in America, for that matter anywhere else, without really understanding history. And so I say in this slide, what happened in 1938? Well, trouble was brewing here in Europe for sure. Those of us who went to Niagara Falls, the bridge collapsed. But none of those things have anything to do with res judicata, except point number 6 is very important. In 1938, following very many years of work by a drafting committee and advisory committee, finally the United States Supreme Court signed into law the Federal Rules of Civil Procedure. And I indicate in the next slide that these rules, in fact, were a seismic shift in the landscape of U.S. litigation, and really forevermore changed how civil cases would be litigated in the United States. Of course, American law is based on UK law because America was a colony of the United Kingdom for many years, and those traditions were brought over to America. Under the English law, prior to 1938, civil cases had to be pled with an amazing amount of specificity, both factually and legally. And under the English law, there were very finite, very strict causes of action. And it was up to the plaintiff to, when filing a complaint for civil damages or any kind of civil relief, to very specifically and elaborately set forth the facts, set forth the law. And the whole idea was that the litigation would be resolved pretty much on the pleadings without a lot of need for discovery. So that's number one. When the civil rules went into effect, it was a 180-degree opposite. And I don't know if any of you have studied any American law, but under the rules of pleading now, what we have is notice pleading. So it's the complete opposite. Instead of a lot of detail, just enough facts need to be pled in order to put the opponent on notice, give them notice of the claim being brought. And then the civil rules have made it very easy to add parties who aren't presently involved in the initial lawsuit, to add claims, counterclaims, cross claims, interpleader, so on and so forth. And also under Rule 15, amendments are to be liberally granted as justice requires, which is means that amendments can be made to the pleadings, parties can be added, claims can be added, almost right up until the time of trial, sometimes in trial, and even sometimes after trial, amendments can be allowed to conform to the evidence. And then we have a very liberal set of discovery rules from Rule 26 to 37, allowing depositions, securing documents. And all these things are intended to then allow the defendant, who has only been given some general notice about the claim, to be able to flesh out the claim, okay? But it's really impossible for us. You might say, well, what does any of this have to do with the preclusive effects of judgments? It turns out that based on the reading I've done, America has probably the most preclusive res judicata reach in the world, some of the articles I've read. And the justification for that is that under these civil rules adopted in 1938, since we have the liberal joinder of claims, the liberal joinder of parties, liberal discovery, it is then fair to have a very broad-ranging and long reach to res judicata. So here's a slide talking about, again, terminology, because this was a pretty big topic back in Maribor. How do we, what exactly is a judgment? Well, Rule 54B of the Civil Rules defines judgment. Judgment, as used in the rules, includes a decree and any order from which an appeal lies. Okay, before 1938, in America, there were two separate courts. There were equity courts and there were law courts. And of course, law courts courts of law deal with basically claims involving monetary damages under the US Constitution, any claim for money damages, any legal claim. Parties are for the most part entitled to a jury trial on those claims. Equity courts, going back to the UK times, the courts found that there would be certain instances in which there were not really causes of action that a claimant who was damaged could neatly fit their claim into. And equity basically means fairness, right? And so in equity courts, the judges had the power to basically do fairness if there was no adequate remedy at law, okay? And so now we're talking about injunctive relief, temporary restraining orders, unjust enrichment, restitution, things of that type. Well, in any event, in America, prior to 1938, you had these separate equity courts and you had separate law courts, and a final adjudication in an equitable court was called a decree, okay? And at that time, a final adjudication of a matter in a law court was called a judgment. Following the 1938 adoption of the civil rules under Rule 54B, since both courts were merged into one, there was no longer a need for the word decree, and every final adjudication, the final amen, if you will, at the conclusion of a case is now simply called a judgment. So I didn't know that until this project, so Besma, thank you. I learned something new, and hopefully you did too. I think lawyers, I find, use a lot of words interchangeably. Orders, for example, an order is not a judgment. I saw many documents in America right up until the time I quit practicing law. The court hereby orders the judges and decrees, but that's superfluous language, really. So coming here to Europe, I would always hear about the drafting of judgments and all this work that goes into judgments and the operative part. And I thought, you know, what the heck is an operative part? Rule 58A provides every judgment and an amended judgment must be set out in a separate document. Okay, it's known as the separate document rule. It must be a self-contained document. Okay. So specifically, it cannot contain findings. It can only be the actual outcome of the case. So here's an example of a judgment, if I can pull that up, or somebody can help me pull that up. Interestingly, I thought in 1938, when the rules were adopted, Rule 84, which is finito, the last rule, was an appendix of documents. And it was an attempt to have form documents so that everybody was on the same page. And in fact, up until December 15th of 2015, there continued to be form documents, and then the court decided we no longer need form documents because lawyers know what they're doing, and that rule is abolished. But in any event, here is, I thought you'd be interested in looking at this. Here is a pretty standard form of judgment. And you can see that you're not going to tell a whole heck of a lot from that, except what court are we in, who are the parties to the case, who won, was it a jury trial, or was it a case tried to the court, and if there's monetary relief that was awarded, how much, what's the pre-judgment rate of interest, what's the post-judgment rate of interest, right? And if the defendant wins, the defendant wins. And, you know, okay, but we're talking, so you say, well, what does that have to do with res judicata? Well, it has a lot, because if we want to try to find out what was actually litigated in this particular case, simply looking at the judgment's not going to help us a whole lot. Okay, we're going to have to look someplace else. And how do I get back to my PowerPoint now?
I don't think it's touchscreen.
You might stay here, otherwise we'll be here all afternoon. Okay, so we have, as we know, two basic scenarios. One, we have a jury trial. Two, we have a bench trial. So this slide, we're talking about, in point number one, we have a case that's being tried to the court, okay? And what happens is, under Rule 52, Federal Rule 52, when we have a bench trial, there has to be findings of fact and conclusions of law. And what happens essentially is, this is how it works. Sometime before the trial is to begin, the judge will instruct the parties to each prepare proposed findings of fact and conclusions of law. And these are in fact very detailed documents, and especially if you had a complex patent case or a complex breach of contract case, antitrust case, can be 100 pages long. It's a real pain in the side of the lawyers to have to prepare these documents, okay? So there's findings of fact. This is what the facts are expected to show from the plaintiff's perspective, the defendant's perspective. And based on those findings, here's what we propose to be the conclusions of law. Well, the judge gets these maybe a week before trial, and the judge can then read these to have an understanding of what the case is about. And then as the evidence is being taken in court, the judge can make a determination, a factual determination, credibility determination of what the actual facts are. Can you find it? No, number one. Yeah, and then how do I just scroll down on it? Or you can make it fit. You can scroll down. So here's an example of how this would look, and I think this is a breach of contract case, and you can see it says findings of fact, conclusions of law.
We can hear.
You can't hear?
Okay.
Okay. Now, so what happens is the court hears the case, okay, and makes a ruling. And the ruling might be an oral ruling from the bench. It might be a written memorandum decision from the bench. And let's say the court says, defendant, you win, the plaintiff isn't entitled to anything. At that point, the court's going to instruct the defense lawyer to go back and prepare a revised set of findings of fact and conclusions of the law that accurately reflects the evidence taken and the outcome, okay? And that is then sent over to the plaintiff's lawyer. The plaintiff's lawyer takes a review of the document. In a perfect ideal world, the judge hopes that the lawyers both agree on it, and the judge would then review it and sign off on it. And that becomes essentially what we might call the operative part, I guess. It's at least a summary of the adjudicative phase of the trial, okay? And oftentimes what I found is that the parties, of course, don't agree on all the findings and all the conclusions, and it ends up in lengthy hearings before the court. But these are really important because if you end up on an appeal, it's the findings of fact and it's the conclusions of law which are usually going to be appealed, number one. And number two, from a res judicata standpoint, a claim preclusion standpoint, you're going to have to go and look at that particular document, and that's going to be the important document that is going to tell you what the facts were, what claims were adjudicated, and what the actual ruling by the court was. And how do I scroll down on this now?
This is only one. Oh, next page, yes, just go down.
Yeah, we really don't have time, but everybody has a copy of my PowerPoint. Okay, so no, but Dennis can, if you're really interested in this, Dennis can provide you with a copy. And you can look at it, but you can just get an idea here that they're very detailed documents. Okay. How do I scroll down by myself? Oh, okay. So here you can see conclusions of law. The court must now determine whether a plaintiff has proven the case for fraud or breach of contract. And basically, in short, the court finds plaintiff has failed to prove that either defendant made a false representation of material fact. As a result, plaintiff is not entitled to damages. So there are two claims, one for fraud, one for breach of contract. And so finding already that the plaintiff failed to prove count number one, we move on to count number two. Breach of contract, and the court concludes plaintiff failed to prove the elements of a contract and therefore is not entitled to any relief. Okay. Conclusion: in light of the foregoing, the court orders judgment on behalf of defendant be entered. And then there would be a judgment similar to the one I showed you a minute ago that would actually be the judgment. Okay. So that's how it works in
PowerPoint.
Yeah, PowerPoint. That's how it works in a bench trial. Stay here. Now, a jury trial.
But the order is not determined or specified. Just because of that, this is the order.
That's correct.
No repetition.
No repetition, and that's why I showed you Rule 54 specifically says that the judgment has to be a standalone document and cannot refer to any other documents. Now, when you have a jury trial, again, the adjudicative phase is going to be the putting on the evidence. The lawyers, before a case begins, prepare jury instructions, which take on different forms. They can be very detailed, a verdict form asking the jury to answer very specific questions, and once the jury signs that form, those are the findings of fact that have been made by the jury. And so that becomes I guess what you might call the adjudicative phase, where the facts have been found. And again, if I can go back to just, yeah, right here, special sample interrogatory verdict form, this one here. Yeah. So here you can see a case in Colorado, special interrogatory verdict form. This would be given to the jury when they go to deliberate. We, the jury, answer the questions as follows. Number one, did the plaintiff prove by a preponderance of evidence the elements of its claim for breach of insurance contract as set forth in the court's instruction? Yes, no. Okay. And here's a whole list of questions. And then please sign and date it. Okay. So let's say in this case, the plaintiff ends up winning the case against the insurance company and they get punitive damages and whatnot. Then the plaintiff would prepare a simple form of judgment, as I showed you before, and it would simply say the case was tried, the jury returned a verdict on September the 11th, 2020, in the amount of X. So again, if you're going back now to see what kind of res judicata effect, preclusive effect that judgment has, just looking at the actual judgment isn't going to tell you much. What you're going to want to look at would be this particular form. And maybe other documents in the file too. You might want to look at the complaint. You might want to look at instructions that were given by the court. Okay. We have to pay him extra compensation for my. So then we have the question raised at the beginning is, when is a judgment a final judgment so as to have a binding effect? The restatement of second from 1982 says that it represents the completion of all steps in the adjudication of a claim by the court short of the execution. Okay. A judgment is final when it disposes of all claims involving all parties to the action. And then the actual last step is after the judge in the federal court signs that one or two page judgment, the clerk of the court then has to enter that into the court docket. And it's that ministerial step of placing the signed judgment into the court docket that gives it final effect. And by the way, from the exact moment that judgment is entered into the court docket, it has binding res judicata effect, unless and until it's overturned by a higher court. So even during an appeal, and if there's an appeal taken, the appeal does not change the fact that there is a binding judgment with res judicata effect. Now, Rule 62 governing stays of proceedings now says that there's a 30-day stay. And so for execution purposes, if you have a money judgment, the judgment creditor plaintiff cannot go out within that 30-day period and begin to execute. If the debtor, the judgment debtor, wants an extended stay, that has to be applied for and an appropriate bond put up. Nevertheless, the stay has nothing to do with the fact that the judgment, until and unless overturned by a higher court, still has res judicata effect. The civil rules in 1938, as I indicated, made it very simple now for there to be multiple parties in a case, and that's certainly very common, multiple claims. So the question becomes, what happens in a situation where, let's say there is a judgment, a summary judgment, for example, granted for on behalf of a plaintiff on one claim against one defendant, or what happens if one defendant gets a summary judgment granted and yet there remain other claims pending. Either the plaintiff has additional claims against another defendant or a defendant still has claims pending against it. What do we do? Rule 54B provides that when an action presents more than one claim for relief, whether as a claim, counterclaim, cross-claim, third-party claim, or when multiple parties are involved, the court may direct entry of a final judgment as to one or more, but fewer than all claims or parties, only if the court expressly determines that there's no just reason for delay, and that's called a 54B, am I up? Yeah, 54B certification. And I have a sample of that, but we don't have time. The rest of the presentation deals with really the same issues that were presented earlier. I would just say one point I would make, though, and the principles are very similar in terms of claim preclusion and issue preclusion, except I would say, as a matter of terminology, claim preclusion is what is called true res judicata. Okay, and I think the important thing about claim preclusion is that claims do not actually have to be litigated for there to be claim preclusion. Give me just 30 seconds. So a common case would be an auto accident. You have your standard auto accident. The plaintiff has property damage and maybe material and non-material damage. Defendant may have a counterclaim on the theory that the accident was partially or totally plaintiff's fault. The plaintiff cannot, what we call, split the cause of action. The plaintiff can't bring a claim for, let's say, material damage and property damage and not assert a claim for non-material damage, say emotional distress. If the plaintiff fails to do that, that other claim is going to be barred. And there was a discussion of merger and bar under the Diplock case. And I would just say that the American law is very similar to what's already been discussed in the Diplock case. Similarly, the defendant in that case has what's called a compulsory counterclaim, okay, and the plaintiff and the defendant needs to bring that claim in the context of that lawsuit, and if the defendant fails to do it, the claim is going to be barred. It'll have preclusive effect, okay. As to issue preclusion, the key distinction there is that there actually has to be an adjudication of the issue, okay? And that issue has to be what I would call material to the outcome of the prior case. It can't be a tangential issue, and it actually has to be determined. So that's really a main difference between claim preclusion, where you don't really have to have the claim litigated, and issue preclusion, where you do. And finally, I would say that America now has what we call a transactional view of, instead of a cause of action. If there is any claim that arises out of the transaction, which is a pretty broad view, those claims are going to have to be asserted, and if they're not asserted, then they're likely going to be precluded by the earlier litigation. Okay, thank you.